Another bankruptcy landmine has to do with the Florida Homestead Exemption. Florida is famous for its homestead exemption in that whatever equity value you have in your home is exempt from the claims of creditors. $1,000, $1 million, it doesn't matter. It's exempt. And because the exemption is created under the Florida Constitution, the Florida Supreme Court has ruled on several occasions that the legislature cannot do anything to infringe upon that constitutionally created exemption. And what that means in practical terms is the statutes that the Florida legislature has passed dealing with setting aside transfers or conveyances done in order to avoid creditors, which are generally referred to as fraudulent conveyances, that those laws have no impact on the homestead exemption. So someone in Florida who's being, let's say, chased by creditors, they can take their money, they can buy a house for cash, or they can take their money and pay down their mortgage. And even if they admit that they did it so that the creditors couldn't get that money, it doesn't matter, because none of the fraudulent conveyances statutes apply to Florida Homestead Exemption. However, when you move into the bankruptcy court, it's a different story, because bankruptcy deals with federal law, not state law. Furthermore, the bankruptcy courts have ruled that because you voluntarily come into bankruptcy, you accept the bankruptcy laws as they are. And under the federal bankruptcy law, the fraudulent conveyances statutes apply to all property. It doesn't matter whether it's Florida Homestead Exemption or IRA or any other property, the fraudulent conveyance statutes always apply. So while someone may put money into their home to protect it from the claims of creditors, under state law, they're going to be protected. If they move into bankruptcy court, they need to be very careful that that issue is properly analyzed to make sure that that money is still protected in the bankruptcy court.